I thought we would try something different for our keynote speaker. I don't love it. We can see what's going on.
Are you going to be singing?
How is that for volume? It gives me great pleasure now to introduce our guest of honour, Professor Catherine Renshaw, who will speak. Catherine's a professor in the School of Law at the Western Sydney University, and I have to have that written because I keep referring to it as University of Western Sydney. Western Sydney University. Now, Catherine is no slouch. Someone might think she's rather an underachiever, but you'll learn exactly what I mean by an underachiever. Not. So Catherine holds a doctorate of philosophy, so she's a PhD. She has a Master of Laws, both from Sydney University, a Bachelor of Law from the University of New South Wales, and a Bachelor of Arts with Honours in History from the University of Sydney. So you now understand what I mean by she is no slouch. She's held a teaching position and research positions in a number of universities and is the founding member, or one of the founding members, of the Network for Law and Human Rights. Please make welcome Professor Catherine Renshaw.
Very much for that warm welcome, and I heard there was a flood of complaints about the quality of the sound, so I expect you to throw things up at me if you can't hear me.
Okay. Can't hear you.
I have never, ever given a speech from such a wonderful and exciting place in such a magnificent home. So I would very much like to thank you, Dr. Moran, for making your amazing piece of living history welcome to us all. So thank you. So it's an honour to share this annual dinner. It's an even greater honour to have a few moments to highlight a few developments in the state of legal education. It's particularly wonderful to be here on such a glorious spring evening when Sydney really turns on its magnificent jacaranda charm. But for those of you who, like me, studied at the University of Sydney, you'll remember that the jacaranda, blooming famously in the quadrangle, held a particular joy, but also a particular peril. Because it heralded the start of the glorious long summer break, but also just around the corner, exams first. Many of you won't be aware that the University of Sydney is not the only university with an extraordinary set of jacarandas. If you travel out to Western Sydney University's campuses at Parramatta or Campbelltown, where I'm currently Dean of the School of Law, you will find that the main drives there are also lined with jacarandas. And there's the same promise for law students of freedom looming large and the more imminent shadow of impending examinations. But beyond the jacarandas, the two law schools have very different identities. First, they're divided by the passage of years. The law school at WSU, which marks its 30th anniversary this year, was created 110 years after the establishment of Sydney Law School, Australia's oldest law school. The first Sydney law graduate to be appointed a judge was John Clancy, appointed to the District Court of New South Wales in 1930. The first Western Sydney law graduate to be appointed a judge was His Honour Justice Abdul Kareem, appointed to the District Court of New South Wales only this year in 2025. So John Clancy was born in Glebe to a father who was of Irish Catholic stock, and he served on the Western Front in the First World War. And Imad Abdul Karim also experienced war. He was born in war-torn Lebanon, and he fled to Sydney with his family at the age of 15. The earliest family photos of the Karim family shows the future judge with his sister and younger brothers sitting on an unexploded bomb as big as a hatchback in front of an abandoned tank. Imad Abdul Karim couldn't speak English when he arrived in Sydney. He learned it, completed his HSC, and enrolled in WSU the first year that the university offered a law program. And like every single one of our students at Western Sydney University, his honour was ambitious, not just because he needed to help his family, not just because the law offers a pathway to social mobility, because it gave him the opportunity to contribute to the maintenance and protection of the Australian legal system and the rule of law. And it's not until you've lived in circumstances of injustice and oppression and the arbitrary exercise of power that you really understand how precious what we have here is. As well as the span of time, there are other differences between my law school and Sydney Law School. I taught at Sydney Law School. In relative terms, there is a very homogenous student cohort. But at my law school, 50% of students are from low SES backgrounds. The majority speak a language other than English at home, and more than half are the first in their family to go to university at all. Last week I attended graduation, and students wear the cultural dress of their families or the country to which they come from. The auditorium was a riot of colour, and it's impossible to name all the countries and peoples and cultures that were represented. There were Hazara students from Afghanistan, there were Tamils from Sri Lanka, there were Vietnamese students, Indian students, Assyrians, Palestinians, Mandaeans, students of Lebanese background, Persian background. And Western Sydney has the largest urban Indigenous population in the whole country. So walking across the stage as well were students wearing the red and the black and the yellow of the Indigenous flag. This year, I had a 220% increase in the number of Indigenous students enrolling in law. So if any of you have sat in an admission ceremony lately in the Banco Court of the Supreme Court, you may have heard the Chief Justice, Andrew Bell, comment on the welcome diversity of the cohort that he's just admitted to practice as lawyers in New South Wales. That diversity is the result of the success of law schools like mine. And we use the word diversity often, but I don't think often enough we think about what it actually means in a profession like law. My students graduate with an undiminished sense of their cultural, religious, and linguistic identity, but also because of their backgrounds, which are often in countries where the rule of law doesn't exist and injustice prevails, with a greatly expanded sense of commitment to the things which make Australia and the Australian legal profession the envy of the world, like Judge Imad Abdul Karim. And this year, on the 2nd of December, in another wonderful initiative of the Chief Justice, we'll bring together the old and the new, the original Sydney Law School and its far newer cousin in Western Sydney, when we hold for the first time the James Martin Moot between law students at Sydney University and my law students. It will take place in the Banco Court. James Martin, who the competition's named after, is a former Attorney General, former Chief Justice, of extremely poor Irish stock who as a schoolboy walked from Parramatta to what is now Sydney Grammar School, courtesy of a scholarship. The moot will be presided over by the Chief Justice, himself an alum of Sydney University, our Judge, Imad Abdul Karim, my law school's first judge, and Justice Lonergan. And of course, I am very desperate for my students to emerge victorious, but more important is the demonstration of the Chief Justice's recognition and support for both the oldest and the newest of Sydney's law schools. So the two law schools, very distinct, but they also share similarities. And it is with very deep shame and embarrassment, frankly, that I have to tell you at this dinner that one thing they share is that neither law school has paid a great deal of attention to the role and function of notaries. Neither law school, in any subject, including the critical legal profession or legal ethics subject, makes any mention of notaries beyond a brief mention in connection to section 302 of the Legal Profession Uniform Law, which explains that where a practitioner has been found guilty of misconduct, then they can cease to accept instructions as a public notary. My sources in both universities tell me that law students rarely ask, wait, what is a notary? And lecturers rarely feel compelled to provide an explanation of their own accord. But I am happy to announce that at Western Sydney University at least, this is about to change. Good. Yes, indeed. One challenge that both universities face is the challenge of AI. AI promises for lawyers the greatest transformation since the advent of email. The promise is improved productivity, improved client outcomes, more effective management of high-volume litigation. All law schools are now grappling with how to prepare their students with the digital skills that the profession is telling us they need. How to ready students for a new tranche of ethical dilemmas that will confront them. In a world where there is a premium on efficiency over accuracy, hallucinations, a world where answers are easy and breathtakingly fast, but where critical analysis, deep understanding of a client's needs, ethical reasoning, judgment, empathy and compassion struggle to find a foothold. In that context, it strikes me that teaching students about the role and function of notaries has much to offer. I think this is because the significance of notaries foregrounds the issue of trust, what it is and how to establish it. It makes clear something that's often very difficult to teach students, which is that trust is not just between them and a client who wants to advance their needs at all costs. Trust is also between the court and the lawyer, and between the lawyer and the society that depends on the integrity of the legal profession to function properly. So I am actually super grateful to be here tonight, and very grateful that I was asked to speak, because it's led me to inquire of my staff and staff at the University of Sydney exactly what they know and teach about notaries. And it's frankly shameful that it's not enough. But that will change in 2026. The other and final thing that it's difficult to teach Gen Z in today's world of instant, fast, shifting narratives of news, real and fake, is an appreciation of history and its importance. The evidence about what our young people know of history and what they don't believe even happened is terrifying. And we teachers of the common law need our students to appreciate and to love the slow turning of the wheel of history and the gradual accretion of wisdom across the centuries. during which legal principles in cases are developed and tested and extended and sometimes overturned. So, again, there, in that respect, knowledge and understanding of the role of notaries is helpful, because you are a very ancient and historic part of the fabric of our law, rich in tradition and history, and you bring to life the fact that our profession needs to cleave to the values of integrity and trust that first distinguish the role of notaries. So, I will be inviting members of the society into my classrooms to speak to my students. So for the opportunity of being able to meet you tonight, I am so grateful. And if you want to avoid being asked to come to Parramatta or Campbelltown to speak to my students, then you better avoid making eye contact with me for the rest of dinner. But finally, just thank you for having me here tonight. It's an extraordinary occasion to be standing here. But mostly I am so grateful because it's provided me with the opportunity to think about new ways of explaining to my students the importance of integrity and trust in the legal profession, in the shape and role of notaries.